Here.
Representative Craven.
Here.
Representative Pagella. Here. Representative Almeida. Representative Canario.
Here.
Representative Filippi.
Here.
Representative Coughlin.
Here.
Representative Hagan McEntee. Here. 11 present, 2 absent. We have one.
Great. We have 2 bills to vote on, 6 to hear, and 8 marriage solemnization bills tonight.
Motion to bundle the solemnization of marriage bills, Chairman.
Vice Chair Costa moves we bundle the solemnization of marriage bills. That's seconded by Representative Agello. All in favor?
Aye.
Any opposition? Okay, they shall be bundled. Passage.
Move passage.
And Vice Chair Costa moves passage of those bills. That's seconded by Representative Agello. All in favor?
Aye.
Any opposition? Okay, those bills have been passed. Let us now take up House Bill 7003 by Representative Craven. Representative Craven, do you move passage?
Yes, Mr. Chairman, I move passage.
Second.
Representative Craven moves passage. That's seconded by Vice Chair Costa and Representative Agello. Is there any discussion? All in favor?
Aye.
Aye.
Any opposition? House Bill 7003 passes as is. Let us next take up House Bill 7025 by Representative Lombardi.
Move passage, Chairman.
Vice Chair Costa moves passage. That's seconded by Representative Canario. Is there any discussion? All in favor?
Aye.
Any opposition? Okay, House Bill 7025 by Representative Lombardi also passes.
Chairman, I make a motion to hold the 6 remaining bills for further study, please.
Vice Chair Costa holds some hold for further study. That's seconded by Representative Blazajewski. All in favor? Aye. Any opposition? Okay, our remaining bills will be held for further study. And let's begin today. Vice Chair Costa. Let's begin today with Representative Ruggiero, House Bill 7034. Representative Ruggiero.
Thank you, Chairman, and thank you, Committee, for taking up this bill. Appreciate your time. House Bill 7034. Essentially what this bill does is it allows DCYF to offer local and national background checks to prospective employees of child care centers as well as foster care. It's required by Rhode Island law, and it's at no cost to the employee or to the business, which is also in Rhode Island law. A little bit of background. Last session, I worked with the child care owners in organizing several workshops that we held with DCYF, DHS, Department of Health, as well as Public Safety. These are all the state agencies with which the child care centers must interact in order for licensing and compliance. And one of the issues that came up in the workshop was the background checks were taking a long time, and it was impeding the child care centers from hiring new employees. So to the credit of Jamia McDonald, the Chief Strategy Officer at DCYF, they listened at these workshops and realized that DCYF actually had the equipment. So she spent the summer talking to law enforcement and the FBI, and we worked through the summer. And what we realized is that what we needed for them to do these background checks was it had to happen statutorily. So that's essentially what this does, this bill. It allows the flexibility for DCYF to also do background checks, which is critical, obviously, for the safety and the well-being of all our children at the child care centers. And DCYF also has regulations requiring that they inspect these child care centers pretty regularly. So if they're also running the background checks, that certainly could expedite any regulatory problems. So I know there are some folks who own daycare centers who will talk to why they would like to have this option. And also Chief Strategy Officer Jamia McDonald is also here from DCYF, and she can really drill down to the specificity of how the agency will handle it. But that's essentially the bill that's before you. Thank you.
Thank you. Any questions? Thank you very much.
Thank you.
Could we hear from Jamie McDonald on behalf of DCYF?
Hey, welcome. Okay. Mr. Chairman, members of the committee, thank you for the opportunity to testify today on House Bill 734, as Rep. Ruggiero mentioned. Important for our agency for a couple of reasons. We've been working with the members of the child care community on trying to do better on customer service, as well as getting their employees to work. When we heard last year that they have waits as long as 6 weeks or longer to get employees into those environments with ensuring their backgrounds and their ability to provide care for our children, we were concerned and worked with the rep on identifying a way to expand our authority. So currently we're already able to run criminal background checks, BCI, the local checks, as well as NCIC national checks. But in order for us to run through the FBI database, they have to authorize it, and you have to grant us the authority under legislation. So we encourage passage of this bill as it is written. Secondly, as the rep mentioned, we do licensing of these facilities, and we're required on an annual basis to check to ensure that these backgrounds and fingerprints are done. If we have the ability to do them, we feel that that will help us efficiently monitor our providers. And I'm happy to take any questions.
Thank you. Any questions for Jamie? Thank you very much.
Thank you.
Could we hear from, I'm going to call up, there are 3 witnesses signed up to testify. So Anthony Cherry, Amy Vogel, and Lisa Furtado.
Hello, my name is Anthony Cherry. I'm the Director of Public Affairs. At the May 4th Group, we represent the Child Care Directors Association as well as the business owners in Child Care Association. We are here today just to publicly thank Rep. Ruggiero and Director and Chief Strategist Tim McDonald for putting this bill into action. This bill is a collaboration of hard work that through the workshops and seminars we identified the issue and really worked towards the issue of solving it. And we have today an owner and part of the HR team for BOCA. Thank you so much.
Thank you. Any questions for Anthony? Thank you.
Good evening, and thank you, Mr. Chairman, House Judiciary Committee, and DCYF Chief Strategist Officer McDonald. My name is Amy Shalquist Vogel. I'm from Dr. Daycare in Boca. We are family-owned child care centers throughout Rhode Island. I'm here to testify in support of this legislation. I understand the importance of child safety and protection and applaud you for making DCYF an option for fingerprinting. Right now, fingerprinting is only available at local and state police departments, which can create a barrier for an employee to start a new job because they need to schedule an appointment anywhere from 2 to 6 weeks out from the day they are offered the job. Opening up the opportunity to have fingerprinting done at DCYF will increase efficiency because of less wait time for fingerprint appointments. This extra location to be fingerprinted will allow new employees that pass the background checks to begin their new child care position sooner versus the 6 weeks it presently takes. This will make Rhode Island a little bit more business and employee friendly. Thank you. Any questions?
Thank you. Thank you, Amy.
Good evening.
1 second. Representative Canario?
Hi. Thank you. Thank you for your testimony.
You're welcome.
So in reading the statute, the Department of Children, Youth, and Families would actually take the fingerprints at your location?
I'm an actual child care business. It would be at the DCYF office in Providence.
So if you had an employee at your business,
yes,
you would go to DCYF and have your fingerprints done there?
Or you could still use the local and state police.
You could use them both?
But they would have to actually pass the background check before they can actually be employed through us. So if we offer a person a job, let's say tomorrow, it could take up, right now, 4 to 6 weeks for them to get an appointment. Where this would help to alleviate that wait time, therefore they become an employee quicker.
Okay, but the actual background check still gets done at the police department?
The fingerprinting, I think, through this could be done at DCYF, state.
No, I understand
I'm sorry.
The fingerprinting gets done at DCYF, but you have a new employee come to your establishment.
Yes.
So they have to be fingerprinted, which they can go to DCYF. What happens with the background check and the BCI check? Who does that? Is that done through DCYF or is that done through the law enforcement?
Jamie, can you maybe you can answer that question better than
No, that's fine. Currently, we run the background at DCYF. So if someone comes in and gets fingerprinted, not for this class of individuals yet, but the ones we're currently authorized for,
Okay.
we take the fingerprint, we run it through the database.
Okay.
The database is the FBI database if it goes national, so they give us the information back, and then there are certain exclusions. So depending on what the background check shows us, there are certain categories of felonies and other sorts of activities that would be automatically excluded, and then there's ones that we're authorized to let them know, and then they can make the decision on whether to hire the employee. So we process the information.
I'm a little bit confused.
Sorry?
The way it's done now is that's all done through the law enforcement agency?
The way it's done for the child care worker,
Right.
they have to go to a local police department or the state police department.
Right.
We, DCYF, have the ability to do it for foster parents and others, just not child care workers.
Oh,
So
okay.
we're proposing to expand our ability to support them in their employment process with equipment and processes we already have in place. We're just expanding the universe of people that would be eligible to come to us as another option.
So is there a fee involved with that?
Statute excludes them from being charged for it.
Okay.
This category of worker.
Thank you so much.
Absolutely.
Thank you. Lisa?
Good evening, and thank you to the Chair, House Committee, and DCYF Chief Strategy Officer McDonald. My name is Lisa Furtado, and I am part of the HR process for onboarding employees to Kids Club, Therapeutic Child Care Services, and Doctor Daycare. I support this legislation. Adding an additional location of DCYF fingerprinting will help to bring employees into our organization quicker and easier. Giving new employees more opportunity of where they can go for fingerprinting will help to make hiring an employee easier. It is difficult to wait up to 6 weeks to hire a new employee into our organization, but this extra location of DCYF fingerprinting will help alleviate this wait time. Thank you so much.
Thank you. Any questions for Lisa? Thank you all very much for coming here tonight. We appreciate it. Also signing up without speaking is Mike Ryan on behalf of the State Alliance of YMCAs. He was in favor of the bill. And we have received a letter from Kim Main from the Rhode Island Child Care Directors Association, also in favor. And so with that, we will conclude testimony on Representative Ruggiero's bill, House Bill 7034. And we will next take up Representative Azanaro's bill, House Bill 7037. Representative.
Thank you, Chairman and committee members. This bill comes about because I was approached by a constituent of mine who is divorced from his wife, and his wife evidently, or not evidently, took their child out of high school and decided to homeschool her without notifying the dad. What this bill does is it requires that custodial parents give non-custodial parents notice of intentions to apply for homeschooling. And then it would also allow appeals of certain school committee decisions about homeschooling to the family court. Basically, that's all it is. And I know there may be some issues with some of the separated parents, but what this is doing is open up communications to the parent who is wishing to homeschool their child to tell the other parent that I am going to do this. And basically that's the gist of what this legislation does. And I'd be happy to, if I can, answer any questions that you may have.
Thank you. Any questions for Representative Azanaro? Yes, Representative Costa.
Thank you, Representative. If you have one parent, say they're divorced, and one parent doesn't want the other child homeschooled, they want to keep them in public schools, are they going to have a mediator, or is they going to have to go back to court? If the child is, say, in junior high or high school, are they going to help in the decision? Because this looks like it could get a little nasty, especially in the middle of a divorce.
I'm sure it could get nasty, but what this person is saying is, I just like to know that this is what's going to happen to my child. There is a process that has to be done. Also, I understand that the parent who is going to take the child out of school must go before the school committee and get approval to do that. Our Rhode Island law, I haven't studied it fully, but I am told by my superintendent of schools in Wesley that it's very, very vague and very wide open. So this might help, it might hinder, but it's a matter of just communicating one person to another that this is what I intend to do with our child.
Thank you, sir.
You're welcome.
Yes, Representative McEntee.
Representative Aznaro, I was wondering if you're going to distinguish between those parents who have joint custody, joint legal custody of their kids, and those that don't, because some people just have a sole custody when you do divorce work, and in that case, generally the decisions are left to the parent with sole custody. So, I mean, the law makes a distinction, and I'm wondering if we should also do that here.
Well, that
if it's
could
for
be
information only, excuse me, if it's for information only, then it's one thing. But if it's part of the whole decision process, if there's sole custody with one parent and no custody in the other parent, other than some form of visitation, generally they are not involved in making these decisions.
Well, I agree with that, and that's where some of the language may have to be tweaked to say that custodials will have that option where someone with just single custodian right may not have to. Mm-hmm. But you know, it's if both parents were aware of what's going on, it might be a little bit less intrusive on one compared to the other.
I agree.
You know, even though one has sole custody, they don't have to, I suppose, but
I think it's a good idea. I'm just wondering if we need to tweak it as far as those two options.
It may have to be tweaked. This was, like I said, our law is very vague, and it was just trying to open up some sort of communication between one parent and the other.
Definitely. Very good. Thank you. Good idea. I really think so.
Thank you.
Thank you. Representative Agello, sorry.
Thank you, Chairman Keeble. Representative Aznaro, you may not have had an opportunity to read it. We just received a letter from the Rhode Island Coalition Against Domestic Violence expressing concerns about this bill. They say, for example, that as a marriage may have broken up, or a non-marriage domestic relationship may have broken up, in part at least because of domestic violence issues. Right. And there might be increased danger to the custodial parent if the other parent, the non-custodial parent, knew of a decision to homeschool the child. So they're concerned about the legislation from the safety of victims of domestic violence and the children.
Yeah, I agree with that, too. There may be situations where there was very bad feelings of a divorce, and someone was moved out of state, and did not, the person that stayed, let's say in Rhode Island, did not want the spouse to know anything about what they were doing because they were afraid that there would be, the person that left would be able to find them and would not want to be found. So these are some of the sticking points about this legislation.
Thank you. Representative McEntee.
Say one more thing. I do quite a bit of divorce law in my practice, and many times when the couple has joint custody, or even if one has sole custody and visitation, we will put that in the agreement if we want communication to be had by both parties, and would also do like decision makings regarding the health, welfare, education of the child has to be communicated between the two, and that both parties have the ability to weigh in on it, you know.
Right.
But, so maybe we could take some of that language, but I can see where it could be problematic if there is an issue with a abusive spouse.
Yes, I see that also.
And we've seen people use the system to just create havoc for young people at times, you know. But thank you.
Thank you.
Thank you. Any further questions for the sponsor? Thank you.
Thank you very much.
Rachel, we have your letter. Would you like to testify as well? Okay. Yes. And we've also received a letter from Judge Fort, Acting Chief Judge of the Family Court. He, too, is in opposition of this bill. So with that, we will conclude testimony on House Bill 7037. And next, take up Representative Serpa's bill, House Bill 7090. Representative Serpa.
Thank you, Chairman Keeble and members. Boy, talk about timing being everything. If you heard the news yesterday, and in case you didn't, I went online and I printed off an event that happened just in Providence yesterday. Channel 12 reported that a 5-year-old was sitting in a car while it was idling while her mother ran in to pick up a sandwich at a fast food place, and the car was stolen with the 5-year-old in the back seat. Fortunately, the child was found and is safe. So Senator Raptakis and I did a little bit of research, and there was another incident recently, too, where a child was taken in a car where the car was idling and no adult was present. We looked at Rhode Island General Laws 11-9-5, and while those laws do address wanton acts of abuse and neglect, depriving a child of food, being in the custody of an irresponsible... Am I on? And there are punishments, indeed, for those willful, wanton acts. However, the law in this state is mostly silent on situations like this, leaving children unattended. And in our research, we found that about 20 states do, in fact, address this. And the other thing I want to bring to your attention is... frankly, what happens if you leave a child in a car unattended is the most that can happen to you is that you'll get a reprimand from law enforcement. Don't do it again. It's not a safe thing to do. But if you go to Title 4, Animals and Animal Husbandry, Chapter 4-1-3.2, if you leave a pet in a car unattended, you can be prisoned for a term not exceeding 1 year. You can receive a fine of $1,000 or both. So there is certainly an inequity there. So Senator Raptakis and I are proposing, and you read the legislative summary, that we thought, and if you think otherwise, we thought 7 was a good age. Leaving a child under 7 unattended in a motor vehicle should be a punishment in and of itself, punishable by a fine of up to $1,000 and a suspension of a license not to exceed 3 years. This seems to be more and more common. Everybody's in a hurry. Oh, I'm just going to run into Cumberland Farms for 5 minutes, grab a milk and grab a bread, especially this weekend. And then you run into a neighbor, and the next thing you know, you're in Cumberland Farms. You're talking for 10 or 15 minutes. The child is unattended. So we don't do it to pets, and I offer to you that we shouldn't be leaving children in cars unattended either. With that, I'll answer questions.
Thank you. Any questions for Representative Serpa? Thank you, Representative. Senator Raptakis? Sure.
Thank you, Mr. Chairman and members of the committee. This bill was introduced. Sorry about that. This bill was introduced last year, and this year, Representative Serpa and I have both bills introduced. Matter of fact, the Senate version will be heard this coming Thursday. And what Representative Serpa said is very important. We have state laws right now that we protect pets more than we protect children. We had an incident up in Rentham Mall where a mother decided to go shopping and leaving a 8-month-old child in freezing temperatures just like today. And yet, what Representative Serpa said is that the statute is silent. Comparing 4-1-3.2 is very severe and very strict. the bill is almost like a guideline. What I need also is to work with my colleagues and see if we can make it just as strict as leaving pets in a car, but also work with what is in current statute. The reason why we picked the age of 7 is because an 8 or 9-year-old can probably physically remove themselves from a vehicle. But yet when you look around different other states throughout our nation, the laws are very strict when you do leave an infant child or a child that cannot fend for himself, herself, to be removed from a vehicle, especially during cold temperatures and extreme heat. I also have with me a constituent of ours who's been from Coventry, who's been working on this issue, and she has given you a packet of information, what happens in other states as far as laws, and the survival of a child, the length of time, heart stroke deaths that occur in children while left in a heated vehicle. And at this time, Mr. Chairman, I'm going to allow further testimony from the witness.
Hello, if you could just identify yourself.
Hello, my name is Terry Sullivan, and I want to thank the House and the Judiciary Committee for hearing me today. I came about with this about 2 years ago. My daughter had broken down, and it was at a gym in Warwick. And while we were waiting for AAA, I saw a woman pull in to a parking lot and to a spot and get out and run into the gym. And, you know, she was behind me, so I was kind of looking in my rear view, just, you know, people watching, waiting for AAA to come. And I thought I saw something in the car, and then I was like, maybe I didn't. So after a couple minutes went by, I got out of my car, I walked over to the car, and I noticed 2 small children in the car. She just left them and went into the gym. So I called the Warwick police, and I said, you know, I need to report that there's children left in the car. And that's how I found out that there was no law protecting these children. We need to advocate for them. They can't advocate for themselves. The officer was very nice. They said they could contact DCYF and get them involved. But, of course, the woman saw me hanging around the car. It had been like 10, 12 minutes, and she came out, and she left. So that's when I started. I contacted my senator, and I said, look, we need to do something about this. I don't think you were unaware that there was a bill, that there wasn't anything about it. And the people I had spoke to, nobody realized that. I am a nurse. I do work with children. So I do come in contact with a lot of people. And I was asking everybody, and everyone was like, yeah, we knew there was no law, but nobody seemed to want to do anything about it. And then the other people, they didn't know there was a law. They were like, are you kidding me? We didn't know there was no law. So I took it upon myself to bother him a lot, to the point of enough emails already. I got it. We'll work on it. And we've been going through ever since. And we came up with 7 because of the statistics. It seems that at 7 and 8 years old, it seems to level off. The kids are well enough aware that they can get out of a car if they get too hot. They can call for help if something's going on and things like that. Know that this isn't only heat stroke. This can happen when it's too cold. This can happen when, how many times have you seen on TV when someone hits the brake instead of the gas and plows into that car? I mean, anything can happen. The children they can be taken. I mean, it just takes a split second. It really does. And I know some people, I myself have 6 children. My husband and I have been married 27 years. I've always taken them in. A lot of times it was a big inconvenience, grabbing them all and bringing them in and trying to get that gallon of milk. But you have to think, you know, what if something happened? I mean, it just takes that split second. So, I mean, and there was already a death this year in Georgia. It was 52 degrees out, and the child suffered heat stroke and died. He was 13 months old. A child's thermoregulatory system works 5 times faster than an adult's. They heat up faster. The radiation in the car, it goes to the car seat, it goes to the steering wheel, it goes to the dashboard. These are the things that absorb the heat. They can get over 180 degrees. It's not just the temperature in the car. So it's very, very dangerous. That's all I have to say.
Thank you, Terry. Representative Filippi.
Thank you, Chairman. And after Senator Raptakis, you said that it was illegal to leave animals in cars, I looked up 4-1-3.2, and I think it says it's only illegal to leave animals in cars when the temperatures, extreme cold or extreme heat. It doesn't ban leaving animals in cars where there isn't that risk. And I think this bill is a lot broader. And I really like the intent. I'm just thinking of maybe a scenario where it wouldn't be helpful to have this law, such as where if a young mother with 3 children that are under 7 pulls up to the gas station and she has to run in and give the gas station attendant $20 to fill up her car. I guess my only fear in that scenario would be that it would actually expose the children to more risk to have to drag 3 kids across a parking lot to get into the gas station to pay for your gas. That's my only concern. I think the intent is great. I'm just concerned that in some scenarios we might put the children in more harm. And I just want to put that on the record. I don't know the answer. I just want to put that out there.
Mr. Chairman, can I just respond to?
Sure, Senator.
Rep, this is just a boilerplate. Representative Serpa will work with the committee and try to sub-A the bill. Look, some members might think that this is too lenient. Some might say that, look, we have to tweak it. And you're absolutely right. This is the first time we're introducing this bill, having a hearing. But when you look at leaving an animal and leaving a child, you're right. Maybe you have a time constraint. If someone runs in for maybe less than a minute or 2 minutes, then you don't go after that individual. That's why we put it out there. And by looking at that other statute, you're right. We're getting tougher on leaving animal confinement in a motor vehicle, but yet not a child. But again, this is starting the debate. And I know we're going to go through this hearing again on the Senate side on Thursday, and there'll be a lot of questions from my side. Again, we want to tailor a bill that's going to send a strong message to individuals not to leave children in vehicles that could endanger a child.
Okay, thank you. Could we hear from, Representative McEntee?
I just wanted to know why you're obviously making this a misdemeanor, right, by the language. A fine not to exceed $1,000, and I was wondering why instead of doing an imprisonment not to exceed 1 year in prison, why you attached it to the driver's license instead for not more than 3 years suspension of the driver's license.
We wanted to have a starting point. Again, we feel that through this hearing process, that members of the committee will work with the sponsor and say, look, we'd like to have a tougher bill to address concern A, B, and C. Great points that you brought up, because you're right. We started as a starting point talking to some members of law enforcement. This might be not harsh enough, but it could be the beginning. We felt that, again, we looked at the other statute. Maybe we can combine language from the animal confinement bill to a new sub-A, and that's why we want to hear from you what your points might be.
Thank you.
You're welcome.
Yeah, but I just wondered, why did you think the driver's license? 3 years with no license for a mother with children is
again, it's
harsh.
up to the judge too. It's not saying you have to suspend it 3 years. A judge can suspend it for a day. It says up to 3 years. So, again, with all the evidence presented in a court, the judge can say, okay, 1 week. We're just saying, we're trying to send, number one, a strong message. We are giving the judiciary the right to give 1 day, no days, up to 3 days. But again, we have to start somewhere.
Yeah.
And that's the very difficulty of a lot of these bills that don't come out of this committee without a sub-A or sub-A 2. So that's why we like to hear from the committee members, and any input that you think working with myself and the sponsor from the House would be helpful.
Thank you.
Thank you. Could the committee hear from Randall Rose, please?
Thank you, Mr. Chair and members of the committee. So I'm speaking in opposition to this bill, which I think, unfortunately, although it deals with an important subject, it takes too much of an anti-parent stance. It blames the parent for situations where no harm is actually done and no harm is likely to be done. And I wanted to say a little bit more about that. It is true there are cases where children have died in cars. It's quite rare, but it does happen. I've looked at the statistics. Sometimes it's when it's due to temperature, it's more often caused by heat than by cold, but it does happen sometimes, and the previous witnesses have explained why. In cars do heat up sometimes. They heat up more than the surrounding temperature. So you do have cases where this happens, even when the temperature is only in its 70s, say. So it does happen sometimes. It especially happens with heat, but if you look at the record of heat stroke deaths, this only happens to a few dozen children a year nationwide. It's very rare. It's not one of the biggest dangers that kids face. It's one of the smaller ones. In fact, if you look at where it happens in the hotter states. So one of the witnesses mentioned a case in Georgia this year. That's the kind of place where it happens. It happens in the hotter states. Last year there were no cases whatsoever in Rhode Island or all of New England. It's not the kind of thing that happens in our climate, and it's not something that's well suited to our situation. And I'm not saying it can never happen. It might happen. There might be a chance that it might happen a few years from now. But the question is this doing more harm than good? This is subjecting parents to a $1,000 fine, and $1,000 is an underestimate because when you take away somebody's license, that's actually a much bigger financial penalty than it looks on the surface. It's likely going to cost them a lot of money, not just to get their license back, but in the economic losses they're going to suffer in between when they don't have a car. So this is a very large penalty, and actually. If you look at the law on the books at Rhode Island, it's already more towards the anti-parent extreme than most states. Most states do not have laws on this subject. Rhode Island already does have a law. As already mentioned, we have a law that sets the threshold at 7 years of age, and it says that you get a warning. Now, 7 years of age is a good cutoff, as the previous witnesses say, because the statistics on heat stroke deaths say that the majority of them are babies and toddlers, sometimes preschoolers, but as the previous witnesses pointed out, it seems not to happen except at very negligible rates for kids 7 and older. So 7 years is a good cutoff, and that's actually what we already have in the law, but it's not. It is a very small risk, and it's unlikely to happen in Rhode Island. Now, I know we were also hearing about the possibility of child abduction, and of course that's a very emotional issue, and parents tend to have strong views about this. And child abduction does happen, but even when it does happen, it's extremely rare for it to happen from a car. So if you look at the statistics on these stereotypical abductions of children, cases where children are taken out of state or across state lines or held overnight or held for ransom, those kind of things. Those kinds of abductions are very rare, only less than 200 per year, and even when they do happen, they're very rarely done for cars. If you do a search about situations involving child abduction in cars, the much more common kind of child abduction is when the abductor is traveling in a car and tries to pick up a child who's just standing on the street. It's very rare that people will try to take a child from a moving car. In fact, when you look at cases like that, they're like the case that happened in Providence yesterday, where nobody was even trying to abduct the child. They were trying to steal a car. They didn't notice the child was in there. As soon as they noticed the child was in there, they returned the child. If you have some idea that children are likely to be abducted from the backseat of the car, it's extremely rare for that to happen. And I'm not saying it never happens, because there are recorded cases, but it is very rare for it to happen. So what this bill is actually doing is it's imposing one particular kind of parenting style on parents. It doesn't say anything about what kind of situations it applies to. It doesn't say anything about how long the children have to be left in the car. It doesn't say anything about what the temperature is outside. It's just a one-size-fits-all bill. It says in every situation, parents can be fined for this or can lose their license. And what it's doing is it's substituting the legislature's judgment for the parent's judgment. And I know plenty of parents are very concerned about this, and they never leave their kids unattended, and that's a reasonable parenting style. But also, there are plenty of parents who are aware of the statistics, who know that this is a much smaller risk than most risks that kids face. And it's their parenting style that they decide when there is objectively not very much risk that they are willing to leave their kids in the car briefly. I think it should not be the role of the legislature to substitute our judgment about what the parenting style should be for the parents' considered judgment, especially in something like this where there objectively is very little risk. So it's like judges. Judges tend to defer to administrative agencies because the administrative agencies have more of an on-the-ground sense of what's going on. I think the legislature should be not micromanaging parents, not imposing a helicopter parenting style. It should be allowing parents to come to their own decisions about how they want to parent their children, even if it's not what the majority of parents would do. So I can understand the need for a compromise on this, and the sponsors have spoken about a compromise, but I think we actually have a very reasonable compromise on the books. What we have on the books says that for children 7 and under, we are going to make sure that the parents are reminded about this. We are going to make sure that they're notified about that there might be an issue. But it doesn't impose these huge financial penalties, because if you pass a law that has a $1,000 fine in it, you're guaranteed to do a lot of harm to some people. But the odds are that having a law like this on the books will not save any child's life. So I think it's because these parents are already able to get a warning, and a $1,000 fine is not going to make that much of a difference in making this less likely. So for these reasons, I think it's better to stick with the reasonable compromise we have on the books, which is already harsher than what most states have, and just not impose such draconian consequences on parents who have a different parenting style. Thank you.
Thank you, Randall. Any questions? Thank you. That will conclude testimony on Representative Serpa's bill, House Bill 7090. And is Representative Williams in the hallway? Okay, let's take a look now at Lita DeSimone's bill, House Bill 7201, which is our annual statutory reconstruction bill. Sue and Mike.
Good evening, Mr. Chairman, Madam Chairwoman, members of the committee. Thank you very much for taking the time to listen to us this evening. The bill you have before you is the annual statutory construction bill from 2015 last year. The bill was passed your committee, passed Judiciary, and then did not make it to the floor. It has just 2 changes to it from last year. Those changes.
Are you telling me we didn't fix the statutory changes last year?
We did not, sir.
It didn't make it at the end of session?
It did not, sir.
I see.
So there are just 2 changes to it. We've removed 2 statutes that we were going to correct last year, 1911 and 1914-1, and those were minor changes that we were able to do without putting it through the statutes bill. Most of the changes in this year's bill are either grammatical changes, incorrect references where there was a typo, or something has been repealed, and a little bit of rewording in terms of cutting sentences into making sentences shorter.
Okay, thank you. Any questions? Thank you very much. As always, the committee appreciates your hard work.
Thank you.
Well, thank you very
important.
much.
All us practicing lawyers appreciate it as well. We run into these things. Okay, so that will conclude testimony on House Bill 7201 by Lita DeSimone. We will next take up Representative Williams' bill, House Bill 7029. Representative Williams.
Thank you, Chairman and members of the board, the committee. 7029 is related to adoption for children. This bill is the third year in process before you, and there's absolutely nothing that is changed from previous year. And this act would permit a petition for adoption and, if necessary, termination of parental rights to be filed by a grandparent without the non-custodial parent's consent when the child is in the sole custody of the grandparent. In many instances, grandparents for a number of years have been the caregiver of the grandchildren because of an array of reasons, the absence of the biological parents. And this, the intent of this bill will just give the grandparents the right to petition the court to adopt their grandchild. Plain and simple. If there's any questions, I will answer them as best I can.
Thank you very much, Representative Williams. And as you did mention, the House has passed this bill twice now and hasn't moved through the Senate yet, but this is the third session we've seen this bill. Any questions? Thank you very much, Representative Williams. Okay, we have one bill remaining by Representative Kennedy. Do we know if, I know Representative Kennedy was chairing his own committee on corporations. Can we see if he wants to come down? He's not going to be able to make it. Okay. Yes, Representative Kennedy is chairing corporations currently, so we will next hear House Bill 7004 by Representative Kennedy. And we have received, in support of this bill, a letter from Catherine Falk, who is the daughter of Peter Falk, the well-known actor most known for his role as Lieutenant Columbo. And this bill would provide that unless a limited guardian, or conservator is specifically authorized by court order, the limited guardian, or conservator may not restrict the personal rights of the ward, including but not limited to the right to receive visitors, telephone calls, and personal mail. And we do, in addition to Ms. Falk's letter, we have correspondence from Kevin Nearney at the Rhode Island Developmentally Disabilities Council, and he supports this legislation. We also have a letter from the Division of Elderly Affairs from Director Charlie Fogarty, and he writes with some concerns regarding this legislation. So I'm sure as the session goes on, we'll be taking a closer look at that bill. And with that, we will conclude testimony on Representative Kennedy's bill, House Bill 7004. And that is our final bill of the evening.
Motion to adjourn, Chairman.
Vice Chair Costa moves to adjourn. That's seconded by Representative Filippi. All in favor? Aye. Any opposition? We are adjourned.